All right, I'm going to reconvene at 6 o'clock our meeting. We've lost a few people in front. If you all want to, those of you who are here want to move to the front, you'll be welcome. We have another speaker. He snuck in. We didn't have him registered, but we're respectful of his seniority and political might, but also, as it turns out, one of our other speakers has decided that they are not going to come, so we have an open space. So Senator Mark Pacheco, you're welcome to our commission meeting. Please join us.
Well, thank you very, very much, Mr. Chairman, and through you to the members of the Gaming Commission. It's an honor to be with you this evening, and I wish I could say the ride down from Boston was without any problem, but hopefully someday in the future, maybe with the help of a casino in this region, we'll actually have commuter rail service. So we'll see what happens. I am here tonight because of the elephant in the room question that is out there, that all of you are needing necessarily to deal with in terms of this particular zone, this particular region of our state. For the record, and for those of you who have not had the opportunity, that we have not had the opportunity to meet before, I have represented this region in the Massachusetts State Senate and the House of Representatives, a combined service this year of 25 years. My very first meeting on what was then called the Government Regulations Committee, as a House member, we talked about the possibility of expanded gaming in the Commonwealth. So that's how long we in the legislature, since I've been there, have been dealing with it, and it went on years before that. Now, we all know what has happened. Massachusetts legislature has passed a gaming bill, 3 resort-style casinos, 1 with exclusivity as a part of, this region, and 1 slot parlor, and we charged a commission, all of you, with the responsibility to try to make sure the best market and the best opportunities for the citizens of Massachusetts actually happen to be the outcome. It's about jobs. It's about creating jobs. That's why the legislature did what it did. I'm sure you've heard testimony from some of my colleagues and others in different regions of southeastern Massachusetts that may feel a little bit differently about when you should utilize provisions that you have based upon what we did in the legislature to open the region to a commercial-based casino. And we gave the discretion to this commission because this is the first time we've been doing this. We've talked about it for 25 years, at least since I've been there. We talked about it many more years prior to that. And not knowing what the circumstances would be, not knowing what would take place relative to even communities deciding to vote for or not vote for a casino in their particular community. All of these things, all of these hurdles need to be accomplished. We gave that trust to the commission to make sure that whatever happened at the end of the day was not only in the best interest of the region, but in the best interest of the Commonwealth of Massachusetts as a whole. So you may hear and I'm sure you have, different opinions about what should happen and when it should happen. You know, some would like to pull the trigger right now and say, open the door for a commercial-based casino. Well, I'm sure you're familiar with the new language that we will be voting on very soon in the Massachusetts legislature in terms of the new compact. And what would happen if that compact passes the legislature and we have a commercial casino in the region and we have Native American casino in the region. Under that compact, the state does not receive any additional tax revenue. It's the same thing that would happen essentially if we went forward with a commercial-based casino and at the federal level, the land is taken into trust and there's no, you know, they can go forward and provide the same options that are allowed under state law. And so I really am here to ask you to give this due time and consideration before we move down the road and find out that we have all made a big mistake. If we wanted to put a time certain in the legislation, we would have done so. If we wanted to give it only a year, we would have done that. Legislative intent, as somebody who's worked on this legislation and pieces of legislation for a long time, it's about jobs. So let me summarize and conclude with this statement. The naysayers around gaming said there would never be a vote passed in a location for a Native American casino in our region. Vote passed overwhelmingly in the city of Taunton. They said there would not be a compact negotiated and approved by the Massachusetts legislature. Compact was negotiated and approved by the Massachusetts legislature. You know what happened at the federal level? They remanded it back to the state and said, go back to the table. It's not exactly what we want to approve. The governor and the tribe have renegotiated a new compact that I assume we will be seeing in the legislature sometime shortly. And I believe we will be approving that compact. The naysayers said we would not see a compact at the local level approved. It's done. The mayor was here and gave you his opinion. Next, we hear at the federal level that there's no way that we're going to see land into trust. The feds have informed the Indian tribe to go forward with a proposal and have remanded it to the regional level to begin the process. And you all heard tonight about the letter from the solicitor talking about all the acreage that's been put into trust since the Kasheri decision. So all of these things that were never supposed to happen have happened. There is no other proposal so far in the Commonwealth of Massachusetts that has come as far as this proposal has. So I'd ask you to give it some more time before you open it up to a commercial-based casino, which, by the way, let me just say this as I finish. I was one of the legislators that were for a number of casinos. I was not necessarily for just 3 casinos. I would have had many more, in particular the slot parlors. I thought the 2 existing license holders should have automatically been granted the licenses. So I'm not looking at it from the perspective of, market necessarily, although that was the intent of the legislature. And if you speak to people like Stanley Rosenberg, the majority leader, who was the point person for the legislature and the Senate on this issue, he studied this very carefully. He went all around the country. He looked at all the options. And he felt that the best market benefit to the Commonwealth as a whole would be what we sent you to be implemented. One final point on the percentages. We know that the new percentages are 21, 17, 15, 0, depending upon what takes place, right? I will submit to you, and it's evidenced by what is taking place in southeastern Massachusetts, Cape Cod and the islands. This region of the state, before the recession hit, was the fastest growing region in the northeast part of the United States of America. And I will submit, as the economy comes back, and it's slowly doing that, we're going to start seeing the housing market back in this region. And in particular, if we have this type of resort facility in this region, even if 15% of the take, I would wager, will bring you in total dollars that could be greater than what Western Mass would bring in. So I'd ask you to consider those factors before you make a final decision here. I thank you very much for listening to me. I'm simply asking that we wait some time before we pull that trigger, because it could be, it could actually kill the intent of the bill and hurt the market share within the region. And I'll be glad to answer any questions that you may have.
Thank you, Senator.
Thank you. Thank you very much.
Questions for Senator Pacheco? When the legislature takes up the compact, you could address this issue for us. The legislature could tell us how they want us to handle this issue, if you think your colleagues would be willing to do that. We look forward to their direction on this if they want to give it to us.
Yeah, and the good thing, Mr. Chairman, and that's always been available to us, and you know the legislative process very well. And we had the opportunity to work together on some issues when you were at A&F, and you know full well that we could, 6 months from now, a year from now, in a budget, change the date and direction. So we certainly have that option. And I would think that absent the legislature taking that move, because when and if we did, obviously we would have changed our position on this, right? We would then have said, it is now our intent to do A, B, or C. You're only hearing that option come forth, quite frankly, from some people who didn't support the bill in the first place. So I'd ask you to look at the intent that was sent you and to please go forward with what that intent really was until we see evidence that this proposal's not going forward. That's not the evidence that we have so far. Evidence is ballot question passed, local question passed, local compact done, state compact about to be redone, federal government indicating a willingness to move forward on this, including providing evidence as of tonight that the solicitor has indicated that there's plenty of land that's been put into trust since this so-called Kasheri decision. Everybody's saying it's dead because of that. Well, that's not the evidence.
Okay.
Thank you.
All set. Thank you very much, Senator.
Thank you.
David Alves, Counselor at Large, City of New Bedford.
For you.
Mr. Chairman, Commissioners, I want to say thank you for the opportunity to appear. With me is a colleague from the City Council in New Bedford, Councilor Joseph Lopes. Just for a little highlight, I'm a City Councilor at Large in the City of New Bedford, Chairman of the City's Gaming Committee. And I've been a City Councilor in the City of New Bedford for 20 out of the past 22 years. And I'm here to seek support for opening gaming, opening the region to commercial bidders. And with all due respect to Senator Pacheco, who spoke before me, he's very articulate, but I hope he respects the fact that respectfully I disagree. Obviously, his pitch, his comments were geared because the casino that is proposed by the tribe is in his district, and he's looking to provide job opportunities in his district, as he should. I'm a city councilor in the city of New Bedford. I represent New Bedford and hopefully the greater New Bedford area in my conversation with you today, and I'm here to look to develop jobs in my region, as any mayor, as you heard today, any councilor, any rep would do. That's what we're elected for. That's what we're elected to do. I'm proud to say that New Bedford, Massachusetts, has been a leader in gaming. It's not new to us. Let me assure you that the comments I make today are not directed or with any disrespect to the tribe. In fact, I've had the pleasure of supporting the first major effort in this Commonwealth of Massachusetts to introduce tribal gaming. It was proposed in our city about 10 years ago. I can remember standing on the front steps of City Hall with the mayor of New Bedford, with labor organizations, Southeast building trades from throughout the area, not just New Bedford, but Southeast region, because we were on the 1 yard line. And the governor at that time also supported gaming. But at the time, legalized gaming was not something that the legislature had an appetite for. Well, now, about 10 or 11 years later, the state legislature, the governor, has an appetite for gaming. And unfortunately, I'm here to argue because we don't have a seat at the table this time. The city is being locked out, and it's unfortunate. I'm not here to waste your time or anyone else's time, but I've thought a lot about the reality. I've learned a lot about the potential for Indian casinos after making 3 personal trips to the Bureau of Indian Affairs in light of my relationship and responsibility for gaming as it appears in the city or proposed in the city of New Bedford. For the record, I'm not opposed to pursuing the opportunity or the tribe pursuing the opportunity to develop gaming in the future. But as a New Bedford City Councilor, I'm here to fight for the opportunity for both economic and employment opportunities in my community. May I say that I also represent a number of tribal members that live in my community, a number of workers from construction unions that live in my community, a number of people from Southeast building trades that live in my community. And as an elected official, I'm here to argue, to ask on their behalf for your consideration. As such, I'm here to request that the Commission not lock my community or any community in Area C from the opportunity to open fair competition to apply for a license. I do so knowing that there's no guarantee that a developer in my community or any other community in Region C would be successful, but open and fair opportunity to apply is what I'm asking for. As I noted, New Bedford is not a Johnny-come-lately to the arena. Our community has taken numerous referendum votes on the placement of a casino in New Bedford, and they passed with majority of support. New Bedford is a city that's been considered by a number of developers for a casino over the past few years. New Bedford realizes the impact a casino would have in addressing our high unemployment, which currently puts us about fifth or less, or higher, I should say, in unemployment in the Commonwealth of Massachusetts, and the impact it will have on potential economic development for the city of New Bedford and for the area is what's important here today. And one of the most pressing areas that would be addressed would be a serious concern for an environmental issue in our city. You know, it was said earlier that no developer would consider opening a casino in our region. But we have developers that have considered. In fact, we have a developer who's considered and considering a casino development in our area who spent over $5 million already in environmental studies, environmental impact, architectural studies. And they were doing it before the compact was signed. They were doing it in light of the fact that casinos were proposed. So we do have people who are interested in casino development, who have put their money where their mouth is, and who have developed a package that I think is more than competitive and something that I would appreciate and feel you should consider. I could fight for such an opportunity to save my community, and I can't fight any harder to come before you. You know, it was said that the compact is signed. There's no question about it. I think the governor is committed to providing the tribe with an opportunity. Many of us here that you've heard this morning are also committed to ensuring that opportunity isn't restricted, isn't limited, isn't something that's discriminatory. We want it open, above board, and fair for everyone. Let the American process, let the cards fall where they may. The issue isn't the compact. The issue is whether or not Kachuri will be changed. I noted to you that I've been to the Bureau of Indian Affairs at least a 5 to 7 year period without any opposition, without any negative comments from community, negative return from the community. It is an important issue without any legislation filed against it. As a dedicated city councilor, elected representative of my city, I have a responsibility to my constituents to advocate for fair, open, and non-restrictive bidding, a process to ensure that everyone is treated fairly in this process. And as such, I'm appealing to the Commission to open the application to as many and all applicants. Once gaming contracts are offered in the state, let the cards fall where they may, as I've noted earlier. Any tribe in the state can apply, but the fate of my community's employment, economic development opportunities, and those of other cities and towns in Region C are in your hands. I ask that you give communities and my constituents, give us the opportunity to apply for jobs, to apply for economic development to save our communities. A comment was made earlier in reference to the Indian tribe having a leg up. I think, unfortunately, they have more than a leg up. They're giving a restricted preference that is, for many of us, considered unfair and unwarranted. Continuing to stall the benefits of the tribe will cost the region potential revenue stream and jobs for years to come. Waiting for the Bureau of Indian Affairs and the pending potential litigation to clear way for tribal development in the region will only delay construction for years. A private developer has come forth, I think, in not only our area, but a number of developers throughout the area seeking to bid. I note that the tribe has always had the opportunity to apply, will always have the opportunity to apply in the future. Open bidding to commercial bidders is a win-win situation. Now, it's been noted that if they open a casino and the Indians, or the tribe looks to open a casino, that there's not enough market share. When I look at the fact that the two richest casinos in the world, Foxwood and Mohegan Sun, I think are less than 7 or 10 miles apart. That's less than the distance between New Bedford and Taunton. That's greater than the distance, I apologize, between New Bedford and Taunton. The market will do based on competition, based on the quality of service they provide. You have the opportunity to open up Region C to commercial bidders. You have the ability to open and make it a fair and open process for everyone. I pray that you will use that to benefit the region and not just the tribe. And I appreciate the opportunity to appear before you and express the concerns that I have, my city council have, and the colleagues on the council. We have submitted a letter. All of the city councils have signed accordingly. It should be in your packet. We're serious about opening it up because we realize that our region, as the senator said, was doing well up until the economy fell flat. We need something to boost it. You have the mechanism to do it, not just for the tribe, but for all of southeastern Massachusetts. I appreciate the opportunity. Thank you. Any questions?
Thank you, Councilor Alves, Councilor Lopes. Any questions for the city councilor or councilors?
Very thoughtfully
Thank you very
put.
much.
Thank you.
Thank you very much.
Appreciate
Thank
the
you both.
opportunity.
Alan Frawley, Vice Chair of the Middleborough Board of Selectmen. Welcome.
Thank you. Good afternoon. I am here today to ask you to please consider opening Region C to commercial bids in a parallel track as the tribe for a gaming license. The Board of Selectmen in Middleborough have voted in support of such an action. Middleborough has been dealing with the issue of tribal gaming for over 6 years now, longer than any other municipality in the state. We have learned quite a bit about this tribe and tribal gaming on a local, state, and federal level, and most of it the hard way. In 2007, Middleborough negotiated an intergovernmental agreement with the tribe and passed a local referendum vote in support of a tribal casino by almost 2-1. Shortly after, the tribe submitted their first land into trust application to the BIA. That was in the fall of 2007. In a notice dated January 19th of 2012, that application was returned incomplete and no longer under consideration, almost 5 years later. The tribe never notified its tribal members of that decision, nor did they notify the town of Middleborough. In the year 2009, a Supreme Court decision, Caccieri v. Salazar, limited the Department of the Interior's authority to take land into trust to tribes that were recognized and under federal jurisdiction on June 1st of 1934. On June 1st in 1934, the Mashpee Wampanoag tribe was neither recognized by nor under the jurisdiction of the federal government. I would like to read a letter to you that came from the case of the Mashpee Wampanoag versus New Seabury Corporation. They were suing the state of Massachusetts for the return of their native lands.
When was this?
This letter is dated October 2nd in 1937 from the Department of the Interior. It is addressed to Chief Wildhorse of the Mashpee Wampanoag tribe. Mr. Wildhorse, Box 17, Mashpee, Massachusetts. Dear Mr. Wildhorse, this will acknowledge your letter of August 29th in which you discussed the status of Indians in Massachusetts. As explained in my letter of December 31st, 1963, the Indian Office can offer no assistance to Indians not members of a tribe under federal jurisdiction. I can hold out no greater encouragement than that contained in our letter dated December 31st, 1963. Your people are the same status as other citizens of the state of Massachusetts and must look to the local authority for assistance.
I'm
That was
missing.
1936.
1936.
Right.
They
Oh,
were
36.
they were
You
not
said
under.
63. Okay.
Yeah,
so-
I'm sorry, 1930,
It was 1936.
1936.
Right.
On June 18th of 2012, the Matchie B. Nash Shewish Band of Poto Indians versus v. Patchak, the court announced that Mr. Patchak's challenge is not barred by the Indian lands exception to the waiver of immunity, and that Mr. Patchak, an individual non-Indian landowner, is within the zone of interest. What this translates to is that the tribe is not protected from lawsuits arising from abutters of the proposed land and trust parcels. In the 1834 Final Trade and Intercourse Act, it states that there is no Indian country east of the Mississippi River. The original 13 colonies entered into the Union with all of their land under criminal, civil, and taxing authority of the Commonwealth or state. There are no federal public lands in the original 13 colonies, and none can be established by the Department of the Interior. The Supreme Court of the United States ruled in 2009, Hawaii versus the Office of Hawaiian Affairs, that Congress is without the authority to reserve or convey a state's sovereign land. Accordingly, the only land subject to the authority of Congress and the Secretary of the Interior pursuant to the Indian Reorganization Act would be federally reserved public domain lands or existing federal reservations. No such lands exist in Massachusetts. Now, if I may switch gears a little bit, not only have I been researching tribal gaming policy, laws, and practices, but I've been reading up a little bit on this commission as well. And Commissioner McHugh, you should get a raise.
Oh, I agree with that.
As part of your mission statement, you will strive to ensure that the commission in its decision-making and regulatory systems engender the confidence of the public and participants, and that they provide the greatest possible economic development, benefits, and revenues to the people of the Commonwealth, to reduce the maximum extent possible the potentially negative or unintended consequences of the new legislation, and to allow for an appropriate return on investment for gaming providers that assures the operation of casino resorts of the highest quality. Now, under the section of tribal gaming, the Commission states that the law acknowledges the legal and political uncertainty at a federal level surrounding Native American gaming by federally recognized Native American tribes in the Commonwealth, while ensuring that its license application in the Southeast region can move forward in accordance with a predetermined timetable. Let me read that again. While ensuring that a license application in the Southeast region can move forward in accordance with a predetermined timetable. Now, as a selectman of Middleborough and having the tribe pursue yet its third potential gaming location in Taunton, it was with great interest that I read the section on surrounding communities. A surrounding community is being defined as a municipality in proximity to a host community that the Commission determines experiences or is likely to experience impacts from the development or operation of a gaming establishment. Has the Commission determined the surrounding communities of this proposed project? I am certain Middleborough will qualify, as we have already submitted statements to 2 different environmental impact statement hearings. Regarding surrounding communities, your website also provides that under the Gaming Act, gaming applicants are required to submit signed agreements between the surrounding communities and the applicant setting forth the conditions to have a gaming establishment located in the proximity to the surrounding communities and a documentation of public outreach to those surrounding communities. This is not a possibility for the surrounding communities in Region C, who are trying to deal with the tribal project. In fact, during the negotiations of the first and second still unratified state tribal compact, not one community was contacted regarding the potential impacts. We have had no input whatsoever. Now, as I read your mission statement, and I do believe you're doing your best to uphold it, I am confused at how different the tribal project is being allowed to treat surrounding communities. I've also read up on your proposed timelines for both Region A and B, and for the slot parlor. You've already accepted 11 gaming applications at $400,000 apiece. Region C did not generate any funds as part of that process. The license fees are $85 million apiece. Region C will not generate any of those funds either. A tribal casino enterprise will not have to go through any of the background checks the other applicants are subjected to, even though the former tribal chairman, Glenn Marshall, was only recently released from prison for his criminal actions in pursuit of a tribal casino. As this commission continues with this undertaking, please take into consideration the numerous hurdles this tribe will face in their pursuit. Keep in mind the significant opportunities for the land and trust acquisition to fail, to also to be encumbered by numerous invalid and time-consuming lawsuits. Keep in mind that as of today, this tribe still, 8 months after the initial deadline, does not have a valid state tribal compact. They are no closer to land and trust today than they were in January of 2012, when their first application was rejected almost 5 years after they first submitted it. Southeastern Mass cannot afford to wait for this tribe any longer. Please open this region up to commercial bids. I am not sitting here asking you to stop this process for licensing a gaming facility in southeastern Massachusetts. I'm sitting here asking you to do your best to adhere to your mission statement, which is to strive to ensure that its decision-making and regulatory systems engender the confidence of the public and participants, and that they provide the greatest possible economic development benefits and revenues to the people of the Commonwealth, to reduce to the maximum extent possible the potentially negative or unintended consequences of the new legislation, and to allow for an appropriate return on investment for gaming providers. That assures the operation of casino resorts of the highest quality. Thank you.
Thank you very much.
Thank you, Selectman Frawley. Any questions for the
No, I think that
Selectman?
covered it. Thank you. Thank you very much.
Thank you. Thank you for reading our mission statement. Carrie Babin, President and CEO of the Taunton Area Chamber. Welcome.
Thank you. I'll be extremely brief. Good afternoon, Mr. Chairman and members of the Commission. My name is Carrie Babin, and I am the President of the Taunton Area Chamber of Commerce. I am here today representing over 500 member businesses in the greater Taunton region. The Chamber is here today not to advocate for or against gaming, but rather for what the proposals that would establish gaming would bring to our region. As a matter of record, the Taunton Area Chamber of Commerce represents both the City of Taunton and the Town of Rainham, proposed locations for gaming facilities. The Chamber believes both of these proposals would bring much needed jobs, both temporary construction jobs and permanent operating jobs, to a region that is sorely in need. When considering all proposals, the Chamber hopes that the Commission would consider not only the benefits to the host community, but also the contiguous communities. Jobs, in our opinion, must be at the forefront of any proposal in your decisions to award licenses. Thank you.
Thank you.
I was brief, huh?
That was very good. Thank you very much. Any
You're a
questions?
model. You're a model
Congratulations.
of brevity. Yeah,
Thank
thank you very much.
Thank you. Selectman Frawley, have those comments been submitted to us, the letters that you quote, that you had there and so forth?
I will be submitting a full packet.
Okay. Okay, great. Thank you. I don't have a name, but I have KG Urban down next. Do we have a spokesperson? Welcome.
Welcome.
Chairman Crosby, members of the Commission, I'm very pleased to be here to represent my client, KG Urban Enterprises. My name is Marcia Sager. I'm with the law firm of K&L Gates, and while it's unusual, I think, in these proceedings to have a lawyer attending, my two principals of KG Urban Enterprises are here, Barry Gossin and Andrew Stern. They thought it was of such importance that I be made available to the Commission in case there are questions about the memorandum I had drafted. My experience is in tribal gaming and land and trust. My role is typically to advise state governments, both the legislative and executive branches of state governments, on these issues, because as you're learning, this is not an easy area of the law, and frequently some education is required. My clients have made me available in the past to various members of the general court while these bills were under consideration. My client is, Andrew Stern is also a lawyer, and he believes that we should always start with your top principles, which would be the United States Constitution. And the Constitution contains what is referred to as the Indian Commerce Clause. Article 1, Section 8, Clause 3 authorizes Congress to regulate commerce with the tribes. And pursuant to that authority, Congress has acted in two respects that are directly relevant to your consideration. First, Congress enacted a statute called the Indian Reorganization Act that allows the Secretary of the Interior to take land into trust for tribes. Secondly, the Congress also enacted the Indian Gaming Regulatory Act, which sets out the requirements for the conduct of tribal gaming on tribal lands. I want to be clear that when the federal government acts under the Indian Gaming Regulatory Act, they're not handing out the same sort of license as you'll be asked to do in these various regions. There's no such thing as a federal Indian gaming license, but rather it is part of a process involving the tripartite federal, state, and tribes in putting together an arrangement that allow for tribal gaming on tribal lands. And why are the tribal lands so important? You need to understand that tribal gaming is not commercial gaming. It is government gaming. It's tribal government gaming, is the purpose of which is to be an economic engine for the tribes, to strengthen the governments and allow the tribal governments to provide for the members of the tribes. It's a different species. States have no authority except for the limited role that's provided in the tribal state compacts that are negotiated as the basis for tribal gaming on tribal lands within the state in which those reservation is located. Now, have you heard from many speakers, and I don't mean to belabor the point, but in 2009, the Supreme Court, in its Carcieri opinion, upended, decades of interior practice by interpreting the Indian Reorganization Act, the statute that allows the Secretary to take land into trust, and holding that the Secretary of the Interior has authority to take land into trust only for the federally recognized tribes under federal jurisdiction as of 1934. That was the year that the Indian...
Could I interrupt you there?
Yeah.
'Cause this is a question that I wanted to raise from your letter.
Mm-hmm.
You're using the words recognized and under federal jurisdiction as if they are interchangeable, or are they two clauses? Explain to me what you think Carcieri actually said.
Chairman Crosby, that is a very astute question. Because the court was interpreting the Indian Reorganization Act, they looked at two different provisions. They looked first at what it meant to be a tribe and then what it meant to be Indian. And looking at the definition of Indian looked at the terms recognized tribe, then under federal jurisdiction. I think that the practice has been for federally recognized tribes to have been deemed to be under federal jurisdiction. I understand, and I think your question is going to Justice Breyer's concurrence in the Carcieri appearance, in a concurring opinion in Carcieri, to the effect that perhaps tribes may have been under federal jurisdiction, but the federal government did not then know it. I have, I think, just a couple of points to make about that. It was not the majority of opinion. It has not been adopted by Congress. If Congress believed that it was as easy as a mere executive interpretation that would allow Department of the Interior to continue to take land into trust under Justice Breyer's concurring theory that a tribe may have been under federal jurisdiction, but the federal government did not then know it, then there would have been no need for Congress, as it has tried to do since 2009, to pass a legislation that would correct the Carcieri opinion. It's been known colloquially as the Carcieri fix, but every Congress since Carcieri went onto the books has tried, from both houses and both parties, to fix Carcieri through legislation. And those legislation have gone nowhere.
But does go ahead.
But that doesn't rule out the possibility that the next time the court or a court looks at this, they interpret it the way Justice Breyer did. The record in Carcieri didn't illuminate the possibility and didn't provide enough for the court to determine the possibility that they had been under federal jurisdiction, but not,
That's correct.
Not recognized.
Because Narragansett, the issue was
Right.
kind of already taken off the table.
Right. So that's just an open question, and one can argue that the Congress didn't have to fix anything because what Justice Breyer was saying may well be the law.
But
I mean, it would be neater and cleaner. Everybody agrees that if the Congress had fixed it.
Mm-hmm.
But But the fact that they didn't doesn't rule out the possibility that on an appropriate record, the court could conclude that what Justice Breyer said was exactly right.
One of my, I would say my primary talking point, Commissioner McHugh, is to address the timing issue. And
yeah.
while what you have
Right,
theorized may ultimately become the law of the land displacing Carcieri or amending Carcieri, the fact of the matter is the first test case in which the Department of the Interior has attempted to exercise that theory is in the Cowlitz case. And as you know, the Cowlitz case, first of all, took 6 to 7 years for the land to be taken into trust, and then immediately upon the decision by the Secretary of the Interior to take the land into trust, immediately 2 lawsuits were filed. And as you probably know, just last week, the district court in the District of Columbia remanded that case for a redo over the Indian land opinion as to whether the Cowlitz could be, the land to be taken into trust could be considered to be an initial reservation. Now, what does that do? Okay, so we're now 10 or 11 years later, and the Cowlitz are going to start over. They're going to get a new record of decision. Undoubtedly, there's going to be the same litigation. So it's a matter of timing.
No, I understand the timing issue. That's a different issue, I think, and I think you agree, than the substance of the law.
There is,
How long it takes to get clarification is a different, is an issue all of its own.
mm-hmm. And as one of the previous speakers attempted to describe by trying to pronounce a very difficult tribal name, the Potawatomi in Michigan, better known, fortunately, as the Gun Lake tribe, you know, with the Supreme Court's Patchak opinion last year,
Right.
the Supreme Court clarified that rather than the 30-day period in which to file a lawsuit, there's now a 6-year window.
Right.
So I'm just saying we're compounding time on top of time. So
Right.
first you have a Carcieri hurdle, and whether it's administratively dealt with or whether there's a Carcieri fix, the bottom line is, and I tried to provide you the data with which you could trust but verify, that just the data will show you that the environmental impact statement process under NEPA that is part of taking land into trust is running 6 years or more. 6 years is on the early side, probably more. And I gather there's some familiarity with the NEPA process on this commission, but you know, it's intentionally a deliberative, slow, lengthy process. It provides for considerable public input, and that's not merely lip service. The goal is to get it right, not to do it over.
Right. Well, your letter is very comprehensive and very helpful, and thoughtfully and thoroughly presents your position, so it was very helpful and comprehensive.
Then let me just move on to something that we have seen repeatedly here, which is a lot of news pronouncements to the effect that Secretary Washburn has now indicated that there was made a preliminary positive determination that the Taunton land would qualify as the Mashpee's reservation. We have seen letters coming from NIGC, the National Indian Gaming Commission, approving, subject to getting land in trust, the tribe's gaming ordinance. Now we have a fanfare of news about the compact. It's the cart before the horse. You understand there are two separate statutory processes that have to go forward. And everything that the tribe has been able to accomplish is on the Indian Gaming Regulatory Act side. Yes, if land is taken into trust, they have taken these next steps. In other words, they've created the cart, but without the land in trust, the horse, that cart cannot move. So all these other determinations, the compact, they're all without legal effect until and unless the tribe can get land in trust. But otherwise, they have no legal effect with respect to land that is not in trust and may never, ever be taken into trust. I just wanted to point out on behalf of my clients, they recognize that a commercial license in this regency, the Southeast region, is very valuable. The studies were done by Spectrum for the governor, by Innovations for the General Court, and by Gaming Market Advisors for KG Urban, and they all are anticipating revenues about $600 million annually. The value is dropping with delay. Why? Because, as you've heard some other speakers say, the There are other very savvy gaming competitors coming into the Boston area and into the Western region. They're going to expand those radiuses, and you know there's a first-to-market advantage for gaming just as for any other industry. You have a chance to build loyalty, and once customers are lost, they're very difficult to get back. With a less valuable license, investors are likely to invest at the low end, not the high end, not on a beautiful casino destination resort, but something that is commensurate to the value of the license. By holding the Southeast region open in the hope that a tribe may one day build on land that is not now and may never be Indian land, the Commission will end up imposing a burden on a region that, as we've heard from many speakers, is most in need of the economic development. Now, based on projected revenues of, say, $600 million annually, holding the Southeast region open in hopes that the tribe will one day have land in trust amounts to a loss to the Commonwealth of $150 million a year. That's $1.5 billion over 10 years. So unless the region is open to commercial bids, this region is left in limbo. The Commonwealth is effectively subsidizing the hope of the tribe on lands that may never be Indian lands, and the Commission will end up denying this region the opportunity for economic development and the employment that it so desperately needs. So our client, on behalf of my client, we ask that Region C be open to commercial bidding. Thank you for your attention. Do you have any other questions?
Any other questions for
No,
Attorney Sager?
no, as I said, I think that letter was very helpful and very
You and your client
comprehensive.
are prolific.
Thank you.
Elias Patuchius, President, Claremont Corp. Welcome.
Chairman Crosby, members of the Gaming Commission, welcome to Southeastern Massachusetts. Thank you for giving me the time to speak today. My name is Elias Patuchius. I'm president of the Claremont Companies, a 45-year-old family-owned real estate investment company headquartered in Southeastern Massachusetts. I'm here to support a competition for gaming, commercial gaming in Southeastern Massachusetts. The obstacles facing the tribe's land and trust application are insurmountable. It could take years before we learn the status of their application. Southeastern Mass can't wait that long. Southeastern Mass needs the economic stimulus and jobs today. Why should we wait and be left in the dust while the rest of the state gets to prosper from commercial gaming and see revenue and job growth? I've had the opportunity to speak to many of the world's top gaming companies, and they have all shown interest in investing in Southeastern Mass, but none of them are willing to commit until the area is open for commercial gaming. We should have competition in this region. There are other viable options. We just heard from the people from KG Enterprises. There are other sites available. There are other developers who want to submit an application. The Wampanoags can compete as well. I ask you today to please open up this region to commercial gaming and put us on the same level playing field as the rest of the state. Let us compete and don't leave us behind. Thank you.
Thank you.
Mr. Patuchius, the companies that you've talked with, were they to locate on the site that you've talked about, they would be running a risk of X degree that they would have a tribal casino at some point in the future, cheek by jowl, with zero tax rate as opposed to the 25% tax rate that the company would be paying. Have they given you insights as to the way they see that and value that and how they discount that impact?
Yes, Mr. Chairman, gaming is all about risk. And many of these companies know the nuances involved with tribal gaming and land and trust and how long it takes to get land and trust. There are many case studies out there, and the attorney for KG Urban just cited one of them. It could take many, many years to get land in trust. And the first mover in the market will have the edge over everybody else. So they are not concerned knowing the history surrounding land in trust and the long lead time involved.
Okay, thank you.
Thank
Any other
you.
questions? For what it's worth, that's the same answer as we've received in writing from KG Urban. Sorry?
If they factor that in, then.
They factor it in and are not troubled by it. Michelle Littlefield, Chair of Preserve Taunton's Future, and Associate.
Good afternoon.
Welcome.
I bring my own tribe. First of all, I want to thank you because I, for one, really appreciate the transparent and open process which this commission has provided us, not only as residents, but as people that are being affected by this process, very, very much so. So I can only say that I wish that that process in Taunton, the political process, which my community faced a year ago with this tribe, was as transparent. It was not. A couple of things I want to address. First of all, the Kacheri decision keeps coming up, and I think it's very, very important to note that 32 states in the United States of America supported and signed on to an amicus brief, as well as Massachusetts, but 31 other states, in addition to Massachusetts, signed on to an amicus brief that supported the Kacheri decision. And that fact alone is the reason why a Kacheri fix will never happen. That will never pass our government through our federal legislature. Furthermore, a couple of things that were addressed today. First of all, I want to note that I'm very, very disappointed that my elected officials, my mayor, that the elected officials for the tribe have felt the need to come today and present their point of view, but then walk out the door. The same thing has happened numerous times in Taunton when we have had public hearings, when we have had other processes in Taunton where we've been presented with questions or the opportunity to speak to the BIA and to MIPA. They say their piece and they leave. They walk out the door. They don't hear what any of us have to say. And I find that very disheartening. I find it very disrespectful to the process. If this was that important to them, you would think that they would stay for the entire meeting and hear everybody out. Unfortunately,
I would point out that Representative Oral is still here. Oh, I'm sorry, two.
And I will say Representative Oral has my vote for life. She is the one person who came forward today and gave you the facts and gave you the truth, as is seen by the district where this casino is being proposed, which is less than a mile from my home. Several people got up here, Mayor Hoy, Representative O'Connell, a few others got up here and talked about the overwhelming vote that happened in Taunton. And I'd like to correct that because that is something that has bothered the members of my group for quite some time. The overwhelming vote in Taunton happened in a few of the wards out of 16. Where this casino is being constructed, or allegedly or hopefully will be constructed by the tribe, is in Ward 4, 4A, 4B. We voted overwhelmingly no. Overwhelmingly no. As did Ward 3, which is also Representative Oral's district. So the entire city did not overwhelmingly vote yes. In fact, the regions closest to the casino have overwhelmingly voted no. The other thing I wanted to point out really quickly that hasn't been mentioned here today.
It was a citywide election, though.
It was a citywide election.
Yeah.
East Taunton is a small district within the larger city. Unfortunately, had we seen this coming down the pipe, we probably would have emancipated ourselves from the city. We didn't get that opportunity. One of the things I want to point out that hasn't been mentioned today is the tribe status of their land and trust application today is incomplete. If this was that important to that tribe to get this land into trust, You would think after a year that application would be complete. It is not. And that is evidenced by the fact that it is not listed in the Federal Register. The EIS is stagnant. I have had contact as recently as this afternoon. One of our members just approached me and said he spoke again today with Holly Johnson at the Massachusetts Environmental Protection Agency. They have not heard one word from this tribe since July of last year when we had our EIS meeting. One thing, and I back up, I skipped part.
Who was that you mentioned?
Holly Johnson, Massachusetts Environmental Protection Agency. As a matter of fact, when I personally spoke with Holly at the end of January, I said, well, we received a draft EIS. A lot of things that we see coming out, and we refer to it as smoke and mirrors, because a lot of what we see that they term progress, when we look into it closer, we realize that it's really not progress. It may appear to be to some, but it's not. And when we got that draft EIS in late November from a company called Epsilon, who works for the tribe, that looked to us like it was progress. When I didn't hear anything for 2 months, and I contacted Holly Johnson, who is in charge of the MEPA process, Holly said to me, we have not heard from them since last summer. Can you forward that to me? To which I responded, no, that's their job. And if they're going to get it to you, I'm certainly not going to further their cause. That's up to them to get it to you. But part of the one thing that has not come up today is something that the tribe is doing. It's called initial dual reservation. I have done a lot of research over the last year, and when this first came out, I made it a point to contact legislatures and the mayor down in Ledyard, Connecticut. I did a lot of research on how this would impact my community, because that's my concern. It's being placed 300 feet from my local elementary school. It abuts my local church. We just built there less than 5 years ago. An initial dual reservation has never been approved by the BIA. And I can assure you it will not be approved for the Mashpee Wampanoags. The 3 tribes in California who have applied for initial dual reservation status have all been denied.
I don't know what this means. I'm not sure if I'm...
The 2 locations?
They're applying, their land and trust application refers to 2 initial reservations, one in Taunton, to which they have no historical ties. As a matter of fact, some of us refer to them as historical ties because they don't exist, and Mashpee. I saw that.
So the land and trust application, I didn't even realize this. The land and trust application is for 2 sites.
It is.
And
Mashpee.
And they could possibly grant one or the other, but as well
Well,
as
I could
possibly
see
both.
maybe they would grant, if they qualified, which they don't, for Mashpee, but we'll get to that in a minute. But the bottom line is that land and trust application is incomplete. The members of Preserve Taunton's Future, we were a ballot action committee that opposed the vote. And we obviously, as the city voted as a whole, we lost that. So at that point, the ballot action committee dissolved. We have, however, remained active as a community. We have gathered together on numerous occasions to discuss certain points in all of this. At this point, we have retained an attorney. And as you well know, Adam Bond, as you well know, there are numerous cases, you know, Kacheri, Hawaii, Cowlitz, Patchak. We have 2 members here that are still in the audience that we refer to as our Patchaks, because they will be filing lawsuits against the BIA, against the tribe, to stop if land and trust were to happen. But we decided a few weeks back, after doing a lot of research, like I said, we've done a lot of work. We've taken, I can't tell you how many days off from work to research this, not only in Washington, but in Boston, at Harvard University and elsewhere. And we have uncovered numerous evidence that supports our position that this tribe does not qualify in any way, shape, or form for land and trust. And in order to get that point across to the BIA and to our governor and to you, the Gaming Commission, we have felt the need to hire an attorney. So at this point, I would like to defer to our attorney, Adam Bond, who represents us as a community, as a group. There's about 10 or 12 of us that have come together and hired Adam to put together this letter to submit our evidence to you.
Ms. Littlefield, I'm sorry, excuse me. Other groups asked to have more than 1 speaker, and we said that was not going to work, that we needed to have just 1. And we also have a 10-minute time limit, and we're very close to that.
Okay.
We will take whatever you all obviously have to submit and value it,
Okay.
but it wouldn't be fair to other
I understand.
organizations to let
Okay.
more than one person speak.
Okay, what Mr. Bond is handing
You
to you.
don't have to go away, but you can't speak.
Well, so he can elbow
Oh,
me
sure, I'm sorry,
when I say something I shouldn't.
Great, thank you very much.
This was a statement that Adam Bond had put together on the behalf of myself and the members of our group. He's been involved with this tribe, like Selectman Frawley, since 2007. This commission will decide the fate of certain economic development in Region C. Presumably, it will weigh the advisability of letting commercial casinos open in Region C and holding up development in Region C to allow the tribe to obtain land and trust. As you are surely aware, to succeed, the tribe must currently show that it was under federal jurisdiction in 1934, as held by the U.S. Supreme Court decision in Kacheri. To that point, I would like to submit to the commission, which we just did, a copy of the letter sent to the Secretary of Interior on that issue. We've also submitted this to the governor. Before I take a risk on a business, I look at past performance and balance that with the likelihood of future success. Compassion and politics have no real place in this decision. Looking at past performance for more than 100 years, the Interior has unambiguously held that the Wampanoag tribe, the Mashpee Wampanoag tribe, were not under federal jurisdiction. For example, on July 10, 1899, the Indian Affairs Commissioner stated that eastern tribes in the states of the original 13 colonies, such as the Mashpee Wampanoag, were residents of a section of the country which constituted the territory of the 13 original states, and that no treaties or agreements were ever made with them by the general government, nor has it ever exercised any supervision or control over them, end quote. The commissioner concluded that such tribes, quote, appearing to be citizens of the United States, left the Secretary of the Interior without authority, end quote. In 1939, Interior assembled a list of tribes subject to the IRA, which you've heard about today. The Mashpee Wampanoag do not appear on that list, nor does any single tribe from the original 13 states. In the 1970s, the Solicitor General of the Interior, Leo Krulitz, testified in Mashpee Tribe versus New Seabury Court and read a letter into the record from the Interior to the Mashpee Wampanoag tribe, which we've provided you a copy of. And it states, that letter is dated October 2nd, 1937, stating, quote, as I explained in my December 31st, 1936 letter, the Indian Office can offer no assistance to Indians not members of a tribe under federal jurisdiction. This jurisdictional statement could not have been clearer. So looking back, there is more than 100 years of history in the clear and unambiguous documents generated by the Interior that we have obtained, which show that the tribe was not under federal jurisdiction as of 1934 as required by Kacheri, for the Interior to have the power to grant land into trust. As we stand here today, and as it has been since the United States Supreme Court spoke to the issue 4 years ago, we and the Interior's own actions and documents show that this tribe does not meet the standard for jurisdiction. As to the future, this tribe is actually no closer to obtaining land and trust than they were 100 years ago or 1 year ago. They have obtained some basically irrelevant bells and whistles, but the 4-year-old core problem still remains. Interior's self-proclaimed lack of jurisdiction to take their land into trust. As to the future, I further note that a grant of their application by the Interior will, and I stress it will, result in lengthy litigation, as it did in the Patchak case. That case was brought in 2005, and it was decided by the United States Supreme Court 7 years later, and the dismissal was reversed. As Chairman Cromwell wrote on July 25th, 2011, I quote, the Mashpee Wampanoag tribe is confident that the Interior has the authority to take land into trust for our tribe, but Kacheri introduces substantial delays. Not only will we have to face direct challenges to our initial reservation, but we will also have to deal with the consequences of litigation
arising in other areas of the United States. Recent cases, still working through the courts, now expand the damage, exposing all tribal trust land to challenge. It is clear that these legal challenges will cost tribes greatly in both time and money, end quote. And that was obtained from an article in Indian Country
Excuse
Today.
me, you're about done. We're getting pretty far past 10 minutes.
Okay, one more paragraph?
Okay.
Okay. I've been down this road once before. You don't have a little red sign. That didn't work for them either. As Chairman Cromwell said in his own words, the commission is looking at a substantial delay and great cost in time due to certain litigation regarding the tribal casino, which will lead to years of delay in Region C development under the expanded gaming laws with no revenue to the state or to the region during that period. I respectfully submit to you that with more than 100 years of the Interior telling the tribe it has not been under federal jurisdiction, and with both opponents of the tribal chairman and the tribal chairman guaranteeing substantial litigation delays as a certainty, the best course of action for this commission to take at this point regarding Region C is to bet on a commercial casino at 25% with the community mitigation and regulatory oversight, and let the chips fall where they may with this tribe.
Thank you.
Thank you.
Very much.
Any other questions? Okay. We're getting close. We have three more, sorry. Thomas Flaherty, Vice President, Sprague Operating Resources. Welcome.
Chairman Crosby, Commissioners, good evening.
Sir.
My name is Tom Flaherty, and I am a Vice President of Sprague Operating Resources. We're based in, headquartered in Portsmouth, New Hampshire. We are the owner of the property in New Bedford that KG Urban Enterprises intends to construct a gaming facility in the event that they receive a gaming license. My firm, Sprague Energy, operates 15 deep water facilities in New England and New York State where we store and dispense fuel oil, diesel fuel, gasoline to a variety of customers, home heating oil customers, institutions, hospitals, schools, that kind of customer class. In addition, we supply mass transit agencies like the MBTA. All the liquid fuel that's supplied on the MBTA buses is supplied by my firm. And through the New Bedford terminal, we supply home heating oil and diesel fuel to customers in the general vicinity. We employ people and pay taxes in the city of New Bedford. Our site also contains what will be the centerpiece of the KG development, which is the Cannon Street Power Station, a decommissioned power station in the center of our property. And we purchased the property back in 2005 from NSTAR. You know, I read in the Globe, and I've heard it said today a few times, that the development in Taunton is far ahead of anyone else. But I also read that they got control of their property in last year, 2012. And we actually were originally started our work with KG back in 2007. But they came to us with this idea to purchase the site and develop it into a gaming facility. They first set foot in our site in 2008 and took a look around, and we entered into a purchase and sale agreement for the property. The board of directors of our firm considered the agreement and finally approved the sale to KG late in 2008, and our owner, the chairwoman of Axel Johnson, was very aware of our negotiations and was pleased with the development ideas because she wanted to see that the property would be left in good hands and would have a future. We looked at KG Urban's management team and some of the other projects they were working on, for example, the Bethlehem Steel project, and could see that these guys could make a project happen very, very quickly. In 2009, we actually granted KG access to our site, and they showed up with a team of specialists, people including environmental cleanup experts, historic preservation specialists, landscape and architects, civil engineers, and design architects. And the number one recurring theme from everybody, I personally hosted dozens of tours through the facility with various constituencies and various consultants of KG and contractors. And the recurring theme, it was just the beauty of the site and the majestic view of the New Bedford waterfront that's afforded from the building that is the centerpiece of the property, the power plant. And KG's commitment to the project has also been financial. When we entered into the purchase and sale agreement, they made a substantial down payment to us and have continued to make option payments to retain control of the site since 2009. The power plant, Cannon Street Station, would be transformed if the project goes forward and the gaming license is awarded to KG. The power plant building itself does not really have any commercial use to our firm, but in application as a gaming facility or as a restored facility, it would be a different ballgame altogether. It would provide thousands of jobs for the region. And of course, as I mentioned before, my firm is an employer of people in New Bedford, but certainly not of the magnitude that would be employed at this site if KG were to develop an operation there. You know, our business is distributing liquid fuel to end users, and there's certainly multiple places to distribute fuel in southeastern Massachusetts. But the opportunity to take a site like this in such a fantastic development, waterfront location, and this opportunity really comes along once in a lifetime in our view, and it certainly would be a better use of the facility than a fuel oil distribution facility. We stand ready to quickly make the site available to KG in the event that they're awarded a gaming license. And the site contains 4 large fuel storage tanks and pipelines, and our demolition work could begin on the site, virtually immediately. As soon as we receive notice from KG that they're ready to go, we're ready to demolish the tanks, and that would happen very, very quickly within a matter of weeks. No permits or any kind of approvals are required to demolish the facility, other than just to simply verify to the city of New Bedford that we are current in our property tax obligations, which of course we are. And as I said, the demolishment of the facility would happen very quickly. So point is that the access to the site could happen very, very quickly, and construction could happen also very, very quickly. So I just want to thank you for the time and the opportunity to address you. Any questions?
Thank you, Mr. Flaherty. Any questions? I'm not sure this is relevant, but just out of curiosity, how does this use comport with what I thought was a planned use by the city of that site or near that site for the staging area for the wind farms? Is that the same area?
The city actually is developing another port facility further south in the harbor from our facility. So I think they call it South Terminal. So it's further. So it would be the city project is a separate project from this one.
So it would be, those two would be compatible?
Yes, for sure.
How long has an oil storage and distribution facility been on the site?
Well, the history of the facility goes back to the turn of the century as an operating power plant, and the facility began to burn petroleum. The facility initially was a oil-fired power plant that probably had been in operation since, I think, the 1940s. And then when the power plant was decommissioned in the 90s and was converted to simply distribution.
Thank you.
Thank you.
All right.
And last but no means least, Stephen Carroll, Real Estate Manager for NSTAR. Thank you for your patience, sir.
Thank you, Mr. Chairman. Fellow commissioners, I appreciate the time today. My name's Stephen Carroll. I'm the real estate manager with NSTAR Electric and Gas Corporation. We are now a subsidiary of Northeast Utilities. We're the largest gas and electric utility in New England. my counterpart, Tom Flaherty with Sprague, kind of described the location of where KG intends or hopes to intend to build a future gaming resort. And I can provide you a little more history and the fact that the readiness of the KG team to actually execute this plan. I should go back a little bit. Tom mentioned that the power plant shut down back in 1991. The city of New Bedford has been wanting to do something with this property for the better part of the last 23 years. We worked very closely with them in an effort to get an aquarium built on the power plant. There was significant amount of work that was done both on the permitting and financing for that project. Unfortunately, that project was never financed, and back in the early part of the 2000 decade, that project kind of just went away. We were forced by statute to divest of that property because it was a former generating plant, and we do not own generating power plants in the state of Massachusetts anymore. So we auctioned it off. Tom Flaherty's firm, Sprague, was the high bidder, and we sold about half the property to Sprague. The remaining half of the property is an operating service center. It's where our crews work out of. There's approximately 200 employees that work out of that facility right now. And they're the crews that work on our electric and gas distribution center system, not only in New Bedford, but in pretty much the entire South Coast community. Back in 2007, we were getting approached by a number of gaming developers, and that was around the time there was a lot of rumblings that gaming legislation was going to be proposed. A number of firms I spoke to, specifically, KG was the one that was more interested in the site than anyone else. We had a significant negotiating period with KG. We started in 2007. We signed a purchase and sale agreement with them in 2009. They spent 18 months investigating this property. Attorney Sager, KG's attorney before, said they spent $5 million investigating the property. The amount of due diligence that's been done on this property is unbelievable. I've been in commercial real estate for 21 years, and I've never seen the level of effort to a point where they are ready to purchase this site, but they've already done all the due diligence. They've already done the title, they've already done the environmental, the survey, the geotech. They've done everything on this property. The key thing for us, a little different from Sprague, is that we still need a facility in the New Bedford area, and we've made a commitment to the leadership in New Bedford that we would keep our operations in New Bedford. And that was a critical part of this deal. We were not going to move out or take 200 jobs out of the city in a city that's already hurting to keep jobs in there in the first place. So that was a key component. And what we did is we had KG go out and secure a site for us in an industrial park in New Bedford, where when they're ready to close, they would acquire this site, which is under option agreement now, and build out that site to our specs. That work has already been essentially vetted and done, which is a little amazing when you think about the fact that they're still looking for an opportunity to compete in Region C, and they've spent that amount of money on our property. And that just tells you the conviction that they have in terms of looking at this site and the feasibility and the once-in-a-lifetime, to quote Mr. Flaherty, about redeveloping a really special site with close proximity to downtown New Bedford. I will say that there is historical contamination on the site. We operated a power plant there for 120 years. There's no threat to the public. It's contaminated, it's contained. NSTAR last year spent about $7.5 million cleaning up a portion of the harbor, working with the city of New Bedford. KG would spend a significant amount of money cleaning up this property. This is a brownfields redevelopment. This is something that they have expertise in, and my company is a very, very risk-averse company. When we enter into transactions, we want to make sure that there's someone on the back end that's going to perform this and perform it appropriately. So we felt confident, and we signed a P&S with KG. They have a strong team with them. And when I hear about people speaking to the readiness of being able to pull the trigger, and the fact that we were actually under agreement, both Sprague and NSTAR, with KG going on 4 years now, and it can go on for a number of more years. So I just want to thank the commission. I really wanted to be able to speak to the readiness and the ability of the KG team to effectively pull the trigger if they're given an opportunity to pursue a license in Region 3. And I want to thank you for your time.
Thank you.
All right, thank you very much.
Questions?
We missed one.
Oh, I'm sorry. Who did I miss?
Fenton, Mr. Fenton from the IBEW.
Oh, I'm sorry. I'm sorry. My brother would kill me.
I was going to say, I'm going to call Jeff.
Yeah.
Thank you. Thank you for having me tonight. Thank you for coming down here.
Thank you for patience.
My name is David Fenton. I'm the business manager of Electricians Union Hall down here in southeastern Mass. We cover Region C. I'm not here to go against any developer that's here. I'm just here to say, let's get this process going. As far as the Mashpees are going, they're on the track to get there. The other developers are in here. They are moving forward also. They want to move forward. But however, as you heard today, that the Mashpees they're on the cusp of getting this thing going. And we're hoping that as the commission looks at what's going on here, that they can keep it going. And I think we're going to be okay because the jobs are going to be created. The industry in the construction world has been awful. We cover all of southeastern Mass, and all of southeastern Mass could use the jobs. So with that being said, that they're moving forward, and I just hope that I'll leave you my written testimony. I don't want to take up too much of your time, and just thank you for coming down again, and hopefully that we can keep moving forward here.
Thank you.
Thank you, Mr. Fenton. Thank you very much. Okay. Thank you very much, David. All right. I think we've heard everybody. Does anybody, before we adjourn, any particular thoughts while everything is fresh in our minds?
I think there's a lot to think about.
Yeah. I mean, the thing that strikes me is, you know, there is a huge data point that we cannot get our arms around, and that is the timing here. I mean, there are different assertions as to the timing. Nobody can point to anything short or long. And if we clearly the legislative intent was to give the tribe a chance, the legislative intent was not to let this go on forever, and they're leaving it up to us to determine what forever is. And they would want us to understand how long this is going to take and make a decision based on that, and I don't know how we ever figure that out. But that's the huge hole here as far as my data collection goes. Anything else? Anybody? Great. Thank you all for your help and participation. The meeting is adjourned, and we will be back in business a week from now. So moved.